Hello everyone, and welcome to our webinar today, where we're going to be discussing wills and lasting powers of attorney. Just to introduce myself, I'm Karen Speedy and I head up the tax and estate planning team here at Whitehead, Monckton. For those of you who aren't aware of the firm, Whitehead Monckton have been around for a very long time. I think it's sort of 240 years now. So we're a long established firm of solicitors, and we've always dealt with wills, powers of attorney for clients over those years. So we're very experienced in doing that. We have a very large team, and we very much offer a bespoke personal service. We started off with an office in Maidstone in Kent, and then we opened one in Tenterden, then Canterbury, then London. And of course, nowadays, we're not restricted by geography because we can meet with our clients via video call. So we're finding that is very much appreciated on all sides, really. And it's working very well. So don't let that put you off. We are very much business as usual, and as I say, meeting clients by video call rather than face to face. So we have two speakers today. Hannah Durston is a solicitor and associate director, and she's going to be taking us through wills. And wills have very much been at the forefront of people's minds in recent times. It's a sort of thing that's very easy to put off and just sort of shelve it for another day. But the pandemic has really made people think about it and really just get on with it. So Hannah will talk us through the benefits of not only making a will, but also making sure it's up to date. And then Hannah will hand over to Josh Parton, who's another solicitor in the team, and he is going to be talking about lasting powers of attorney. And we mention those because we always discuss those whenever we meet clients and talk about wills. They're very much part of the whole succession planning package because they're such useful documents. If you lose capacity and aren't able to make decisions for yourself, and you've got a lasting power of attorney in place just waiting in the wings, then whoever you've appointed under that document can get on straight away and step into your shoes and take over for you. So they're very useful. And then at the end, once we've heard from Hannah and Josh, we will deal with any questions. So if you think of anything as we go along, please type it into the chat box and we'll deal with those at the end. But if we don't get a chance to deal with them, or if you think of something after we finish, then you'll have our contact details, and obviously you can check us out on the website and contact us through that. So please do just get in touch. So without any further ado, I'm going to hand over to Hannah. Thank you, Hannah.
Thanks, Karen. So as Karen said, I will be talking mainly about the reasons why you should think about making a will if you haven't done so already, or perhaps updating your will if you did it a while ago and haven't reviewed it. So I'm just going to run through a couple of statistics first, because sadly we've had to sort of contemplate our own mortality a bit more, which sounds rather dreary, but everybody's had a bit more time on their hands with everything that's going on at the moment, and not to mention the awful, rates of infection and deaths as well. So making a will, I think, has probably gone higher up that to-do list, and hopefully people aren't sort of parking it as much as they were before. We were certainly quite busy, especially at the beginning of the lockdown last year, with doctors in particular wanting to get their affairs in order. The latest statistics say that there's 54% of the adult population currently do not have a will or a valid will in place. Hopefully that's gone down a bit in the last year, and hopefully it will keep coming down because it really is very important. And thinking about why people haven't made a will or haven't updated it, is it tempting fate? I don't think it is, but I think people often think well, if I make a will, I'm going to die. So that's, a thought process that we've heard of before. And people don't like to contemplate their own mortality. It's not a very nice thing to think about. But sadly, it is going to happen at some point. So the more organised you are with it, the better. Simply not getting around to it, as Karen said before, it's one of those things that just gets put off and off. It's never the most important thing to do. There's always all sorts of other things going on in people's lives, so just not getting around to it. There's a preconception that it's too expensive, and also that people seem to think that your estate will go to your family anyway. And I will run through some case studies, particular examples about that anyway. On the expensive bit, we will come on to fees at the end as well. Karen will run through that for us. But what I want you to have in your mind a bit is the cost of not making a will. So some reasons which I'll run through as to why you should make your will. You've spent your whole life building your estate, and it's really important that it passes to the beneficiaries that you want it to pass to, rather than the rules that the government put in place, which is what will happen if you don't have a will, and that's called intestacy. So you can control who, by making a will, you've got testamentary freedom, which not every country has. You can choose who your assets pass to. So you can name as many beneficiaries as you want to, whether it's family or not, family, friends, charity, whatever, you can choose that. You can also choose your executors. So you've got the control of who actually deals with the administration of your estate and who deals with making sure that your wishes are carried out. And in most cases, somebody in your family is the appropriate person to do that. Sometimes there are no appropriate family members, in which case you could appoint a professional to do that for you to make sure that your wishes are carried out. A really important one, and this may not be apparent to everybody listening, but a really important one is protecting your children. So you can appoint guardians in your will for your minor children, and that would ensure that the people that you want to look after your children, if something was to happen to you while they're still young, that's your choice, rather than then sort of falling into the social services system, at which point they may or may not be looked after by existing family members of yours, so your parents, for example, or siblings, something like that. You may also have other beneficiaries who are vulnerable, so that could be not just minors, but you may have beneficiaries who are disabled or otherwise vulnerable, perhaps just not very good with money. And if that's the case, there are certain types of trust arrangements which can be set up in order to make sure that those people who need protecting are protected. And also you can appoint people to carry on managing those funds for them, however much money is left to them, that money can be looked after by the people that you choose, and they're called trustees. Of course, many of your beneficiaries will be more than happy to receive cash outright, and only you will know those people as to how appropriate that is at the time in their lives in particular. Something that we talk about quite a lot actually is how old children should be when they inherit money, whether sort of 18 is too young. So it's becoming probably more common that people are saying 25 should be the earliest age, with a view to being able to help them out with education or sensible things before that. So outdated trust arrangements and tax planning. The inheritance tax rules changed back in 2007. So if your will predates 2007, it may be that you have trust arrangements in that will which is now outdated, because I'll come on to inheritance tax in a minute, but those rules did change some years ago now. And by the effective use of succession planning, you may be able to mitigate inheritance tax payable on your estate after your death. And again, by effective use of succession planning, you may also be able to protect your protect your estate from future care home fees, and that's becoming a bigger concern for people at the moment, because the cost of care is so high to be sort of looked after in our old age, and that's certainly something that we can discuss and help with as well. Many of us have digital accounts these days. We're trying to cut down on paper, so we're asking the banks to send us statements just online. So after you've died, there won't be a paper trail for those accounts. So your executors won't know what they're looking for unless you've told them about it. You might also have online accounts like PayPal, online gambling accounts, for example. And you've probably also got social media accounts such as Facebook, Twitter, I could go on, and all of those need dealing with after you have died. Personal possessions is an important one as well. You may have family heirlooms which you wish to pass down to certain people, such as jewellery. You may just have, silly little things that you said to, your children or your grandchildren, yes, that will be yours one day. You may have artwork, cars, any particular items. If you want those to go to particular beneficiaries, then that can go into your will arrangements as well. Some people want to support a charity after they've died, whether that's a combination with family beneficiaries, or if you've got no family and want everything to go to charity, then that's an option, and that's quite tax efficient as well, which I'll come on to in a minute. I think this bottom point, the last point on this slide, is actually the most important. By writing down your wishes, it's clear what you want to happen. So anybody after your death saying, "Oh, well, I'm sure he or she wanted this," well, it's written down. So hopefully that will avoid any arguments in the future, by you making your will and keeping it up to date, so that your beneficiaries and your family know that those were your recent wishes. And I think that peace of mind that comes with that, and with knowing that that your affairs are in order, is really valuable, because you can know that when something does happen to you, and we hope that won't be for many, many years to come, but when that day does come, you can be happy that you've got everything in order. And that peace of mind really counts for a lot. So I mentioned I'd run through some case studies. The first one here is the preconception that all of your estate will go to your spouse. So this is for a married couple. And in this case, the husband dies without a will, leaving and his total estate is £570,000 for the purposes of this. So that might be, a house, some savings, some investments, perhaps a car, things like that. All amount, the whole 570,000, will not pass to his wife, his widow. Instead, the wife will receive, sorry, this is if there is no will in place. I should have stressed that at the beginning. So if this is dealt with by way of an intestacy, so the government's rules, the wife will receive an outright gift of the first 270,000. That's the amount that the government have allocated that can pass to the surviving spouse. The rest of the money, so the balance, will go, half of that will go to the spouse, and the other half will go to the children. So the children will end up with £150,000 shared equally between them, however many children there are. That may not be, your wishes. You may wish for it all to go to the spouse, and there's certainly tax advantages to everything going to the surviving spouse, which I will come on to. So there's some food for thought there. The second case study, which I'm going to go through, is an unmarried couple. So no wills in place. This couple, John and Jean, they've lived together for 20 years, a really long time, and they've got a child together as well. They decide never to get married, or don't get around to it. So in this case, the partner, John, dies first, 300,000. Now, Jean, in this case, although they've been life partners, will not inherit anything at all. Nothing goes to Jean because they're not married. And that's what the intestacy rules say. Instead, the child will receive the whole estate of £300 outright. It's more and more common now that there are many couples living together and not getting married. So if this scenario resonates with you, then you very much need to sort out a will to make sure that this doesn't happen. Otherwise, the property can end up in the child's name, and potentially a roof over your head be lost. So that's what would happen in that scenario, and of course a will would change that. If Jean wanted some of John's money, some of John's estate, to support herself, she would actually need to go through the court system to dispute the intestacy rules, but she would be claiming against her own child, which you can see would be a very difficult situation for everybody to deal with. So if John had just made a will providing for Jean, then that whole situation and expense would be catered for. I mentioned inheritance tax earlier, and I will run through very sort of in simple terms or brief terms what the current rules are. So as they are at the moment, every individual has what's called a nil rate band, which is effectively a tax-free allowance of £325,000. And to that, if you leave your residence to your descendants, then you will have an additional £175,000. Anything, moving on to the exemption section, anything that you leave to your spouse is free of tax. So you could have an estate of £1 million, and if you pass all of that to your spouse, that's completely free of tax. Same with charity, there's no inheritance tax payable on charity gifts either. Now, let's say there's a married couple, and when the first person dies, they leave their estate to their spouse. So it's free of tax at that point. Then on the second death, the second person to die will have their own tax allowance. They will also have the nil rate band from the first person to die, because that person effectively didn't use theirs. So they're going to have in total £650,000 of, so 2 nil rate bands together. They will also have the benefit of the first person's residence nil rate band. So at the moment, that's £350,000. So in total, there's potentially as much as £1 million worth of tax allowances. And by looking into all of your, your will and your succession planning, we can try and make the most of those allowances for you. If you've got assets in certain types of businesses, or if you've got farming assets, then they may qualify for relief from inheritance tax as well. And usually those circumstances are quite specific. So if that's relevant to you, then we would discuss that with you. There are some lifetime gifting allowances which you can make use of as well if you're in a position where you're trying to sort of get money out of your estate to try and reduce its value and perhaps give children or grandchildren their inheritance early. Some of these you may have heard of, some of them are a bit more unusual, but all still perfectly allowable. The first is that you can give, each individual can give the amount of £3,000 per year to their chosen recipients. If you didn't use last tax years, you can use that one, but you can only go back one tax year. So this year you could give 3,000, and then when the new you could give 6,000, and then when the new tax year ticks over, then you could give another 3, and then you could keep doing that going forward. You can give £250, not 250,000, £250 per individual as well. So if you've got, I don't know, 6 grandchildren, you can give them each £250. If anybody is getting married, you can give them a wedding gift of £5,000 if it's your own child, £2,500 if it's a grandchild, or £1,000 for anybody else. And there's no tax consequences to doing that in terms of inheritance tax. If you wanted to make a bigger gift to get a bigger lump out of your estate, or to help out a child, perhaps you wanted to help buying a house for a child, that would be what's called a potentially exempt transfer, or a PET. And any gifts of those, a bigger value, you have to survive 7 years from the date of making that gift. So if you're thinking of doing that, often it's better to do that sooner rather than later, because we never know, when our 7 years needs to be up by. So if you are thinking about making gifts, then that's something that we can talk to you about. This bottom one on here, gifts out of excess income, is less well known, I think. But if you've got income coming in, perhaps from a pension or excess employment income, then that's excess to your needs, and that has to be reasonable needs. You can't sort of, you know, starve yourself or not put your heating on, for example. But if you've got money coming in which is genuinely excess to your needs, you can give away that income as well, on a regular basis, and that doesn't come into your inheritance tax calculations. The residence nil rate band a bit more. This came in back in April 2017. It feels like it's quite new, but actually that was quite a long time ago now, so time must be flying. It's not quite as simple as you get £175,000 of extra band per person. That would have been too easy. Instead, the government have come up with various rules which are actually quite complicated when you dig into them. But the crux of it is that you have to have a qualifying residence, so you have to own your own property, and you have to give that to your direct descendants. So children, grandchildren, in this case actually stepchildren are included as well. So when it was introduced in 2017, it wasn't as much as £175,000. It's been going up in quite big chunks each year. So we're now at 175,000. But from this April coming, it will just go up by the consumer price index, which is more or less next to nothing. So we can sort of, for round figure purposes, keep it at 175,000. Confusingly, and perhaps unfairly, this doesn't apply if your estate is over 2 million. It starts tapering down. You start losing this allowance. So that's something to bear in mind. And perhaps you can make, you know, pets gifts to reduce your estate below that, to make sure that you get this tax allowance. And that's something that we would discuss with you if your estate is over the 2 million. But to downsize your property, so let's say you have a house worth 350 now, but when you get a bit older, you want to move into a smaller place that's easier to maintain. There are rules surrounding that as well, which we could discuss with you. And as I said before, it is transferable between spouses, so usually applicable on the second death, this tax rule. And just a point at the bottom there, the nil rate band, which is the £325,000, which I spoke about before, has been frozen until this year. That decision was made a number of years ago. Obviously, they've got lots of things to be talking about at the moment in terms of budgets, but I don't expect it will be increased anytime soon. So those are the rules as they are at the moment, and it's important that you sort of keep an eye on the government changing their minds on any of this information, and please discuss it with us if it's something that's of concern to you. So I've given you quite a lot of figures there. If there's anything that you want clarified, by all means get in touch afterwards. But I will now hand over to Josh, who is going to talk about lasting powers of attorney. So if you've got any questions on this part, by all means tap them into the chat now, or you can wait until the end. That's fine, but I will hand over to Josh.
Thank you very much, Hannah. Good morning, everyone. So as Karen alluded to at the start, when considering your will, it's also a good time to consider the creation of lasting powers of attorney. So what are they? Well, lasting powers of attorney are legal documents that allow you to appoint individuals that you trust, i.e. your attorneys, to make decisions on your behalf if you become unable to do so yourself. Now, there are two types. We have the Property and Financial Affairs LPA, and this pretty much does what it says on the tin. So the types of decisions which your attorneys might be making under this document might include liaising with financial institutions in relation to bank accounts and investments. It may also include such things as claiming benefits or selling property. Okay, so all those sorts of decisions that you would possibly expect to come within that remit would be included. Now, you might have heard already of something called an enduring power of attorney, and these do cover the same types of decisions as a Property and Financial Affairs LPA. Now, you can't, it's no longer possible to make an enduring power of attorney, but any correctly executed enduring power of attorney, which is already in place, does remain valid. But even if you do have one of these already in place, it is at least worth reviewing the same just to ensure that it does provide your attorneys with all the powers that they may need. Now, the second type of power of attorney is health and welfare. So again, you can probably think of some of the types of decisions which would come within that remit, but you've got routine decisions, everyday decisions such as diet, dress, or daily routine, and bigger decisions such as where you might live or the type of care that you should receive. In particular, you would also need to consider the role of your attorneys should you require life-sustaining treatment. Now, there's a section dedicated to this particular decision within the document, and as you can probably imagine, that is the most difficult decision anyone could possibly have to make. And you have the option of actually choosing whether you do grant that power to your attorneys, grant that authority to them to accept or refuse the life-sustaining medical treatment on your behalf, or whether you would prefer to reserve that power to medical professionals. And we find a lot of clients have strong views on this, and the default position without the document in place is that the views of doctors would take precedence over those of family members. You may have already also heard of an advanced decision, which is also known as a living will, and you might already have one of these in place. And this allows you to write down any treatments that you don't want to have in the future in case you later become unable to make or communicate decisions for yourself. So the difference between an advanced decision and a health and welfare LPA, well, the advanced decision covers refusals of medical treatment only. It also only applies to the treatments and circumstances that you write about in the form. It won't apply if you're in a situation that isn't covered by the advanced decision. Whereas with an LPA for health and welfare, your attorneys have the authority to make any decision about your health and welfare, subject, of course, to any restrictions that you might choose to include within the document. So if we move on to the next slide. So when should you make lasting powers of attorney? Well, the first thing to say is that lasting powers of attorney are not just for the elderly. And that's a common misconception that people think, well, you know, it's old age and the risk of living with dementia and being diagnosed with dementia. But mental or physical incapacity can, of course, occur any time in life, and planning ahead will ease the potential burden on loved ones. No one knows what life has in store for any of us, and for example, any of us could be involved in a car accident or have a stroke at any point unexpectedly, possibly leaving us in a position where we're unable to make decisions for ourselves. And one way I often get clients to think about LPAs is almost like an insurance policy. Obviously, you hope that it will never need to be used, but if the worst does happen, it's in place for peace of mind to make things easier. Now, at the time you execute lasting powers of attorney, you must have mental capacity, which means that you must be able to retain information, weigh up the various options associated with that information, and make an informed decision. To confirm that you have the requisite capacity, somebody needs to act as your certificate provider for the purposes of these documents. Now, the certificate provider can either be a professional with relevant skills and expertise, which could be a solicitor or a healthcare professional, or alternatively, it can be an adult who has known you personally for at least 2 years. Now, again, you can probably tell acting as a certificate provider is a big responsibility, as that person is confirming that you have capacity when you're making that document. And if capacity is questioned at any time after the LPA is created, your certificate provider would be questioned about how they formed their opinion. So who should your attorneys be? Well, quite simply, people you trust who will be capable of managing your affairs. It's very usual to appoint close family members, such as your spouse and your adult children. You should consider the appointments carefully, as your attorneys will have scope to effectively step into your shoes and make decisions as if they were you. So again, that idea of trust, you must trust them implicitly. Alternatively, if you don't have any family members who you feel would be appropriate to act, or friends even, you may wish to appoint a professional, such as a solicitor or accountant. And the directors of Whitehead Monckton, for example, are happy to take on this role in most circumstances. However, due to additional obligations that are placed on professional attorneys, we would ask that if you did choose the directors of Whitehead Monckton, that you sign up to a program that we've designed, which is the Professional Attorney Program. And basically with this, we would encourage you to meet with us on an annual basis, maybe a quick catch up over a coffee, just to ensure that we're up to speed with your current affairs, which would, obviously in turn best equip us if we had to step in and make decisions. Moving on to how you should appoint your attorneys. Well, the first thing to say is that you can appoint as many attorneys as you wish. However, it is arguably impractical to have any more than 4 acting on your behalf at any one time. You can also appoint replacement attorneys to step in should your original attorney or attorneys become unavailable to act themselves, either through their own mental incapacity, through their own death or bankruptcy, for example. And we would certainly recommend you always have at least 1 replacement if you're only appointing a sole attorney to act in the first instance. If you do appoint more than 1 attorney, you need to think carefully about the way in which you would want them to act. So you can appoint them either jointly or jointly and severally. And jointly essentially means that they must agree in respect of all decisions. Okay, there's no opportunity for one attorney to make a decision without the other. But of course, this is inflexible, because if one attorney cannot act, the other one is unable to do so. So the more flexible option, the more practical option, is often to appoint attorneys in a joint and several capacity. And this means that although they should consult with each other wherever possible, it does mean that if one can't act for whatever reason, if one's on holiday, sort of temporary thing, or if it's more permanent, they're just unable to act because if they've passed away, for example, then the remaining attorney can still act. And of course that adds further value to the documents, because what you don't want to do is make these documents and then find that actually they're no use at all because the people you've appointed aren't able to make those decisions. Okay, so that's that. So if we could change the slide again, Hannah, please. Okay, so we've got a little bit here on registration. Now, it's important to point out that your lasting powers of attorney cannot be used by your attorneys until they are registered. So there's a signing process that needs to be followed, which is quite complex, and it's more involved than executing your will. And again, we spoke about enduring powers of attorney earlier, and if you know about these, then you may realise that they can be used usually as soon as they've been executed, and need not be registered until mental capacity has been lost. But with lasting powers of attorney, you have to register them before they can be used. So it's an extra step after everybody has signed the documents. And in most circumstances, which it's common sense really, we would recommend you register the documents immediately to avoid any delay at the time that they might be required, because the registration process does take some 10 to 12 weeks. We have to send them off to the Office of the Public Guardian, and that's their timescale for processing applications. In terms of storage, we are happy to store original documents for clients for safekeeping if you so wish, and the same can be said for original wills. Use by attorneys. Now, you can provide authority for certified copies to be released to your attorneys at their request without having to obtain your express consent or obtain medical evidence of lack of mental capacity at the time that they are proposing to act, which can obviously speed things up. Again, most people tend to go with that because you've appointed people that you trust. So if you're suspicious about circumstances that your attorneys might be asking for the document, then you might want to reconsider whether they're an appropriate person to appoint as an attorney. And when do you want your attorneys to act? Well, it's important to distinguish between both types of lasting power of attorney. So with the lasting power of attorney for property and financial affairs, you can choose for your attorneys to be able to act as soon as the document has been registered, so whilst you retain mental capacity, or you can select the option that it can only be used once you've lost mental capacity. And of course, if there's any doubt as to that in terms of the attorney forming that view, then obviously it would be sensible to obtain a medical professional's assessment of capacity. So if you go with that first option, then the important point to remember is that whilst you retain mental capacity, you are always in control of all decisions affecting you. Your attorneys can only make decisions on your behalf if you allow them to. They are responsible to you for any decisions you let them make. Now, with the health and welfare lasting power of attorney, you don't have a choice in terms of when your attorneys would be able to act under this document. They can only act once mental capacity has been lost. And above all, in respect of both documents, your attorneys have a legal duty to act in your best interests, not in their best interests, in your best interests. And any concerns can be reported to the Office of the Public Guardian, who carry out oversight on that basis. So we move on to the final slide here on lasting powers of attorney. So you might be thinking, well, what happens if I don't put them in place? Well, if you become mentally incapable and do not have lasting powers of attorney in place, and remember that life is unpredictable, who could have thought that we would be in this position, just over a year ago with the whole COVID situation. So without these in place, your relatives, your friends would face long delays and expense in applying to the Court of Protection for what is known as a deputyship order. Okay, although in some cases it may be the only option, there are three big disadvantages really with this as compared to putting LPAs in place. So the first one we can talk about is delay. Okay, it can often take 6 to 9 months to apply for and obtain a deputyship order, and it can't even be guaranteed that the court will even grant it. In the meantime, your assets, which can also include joint assets, can be frozen and made inaccessible, making an already difficult situation that much more stressful for your family. In particular, the court is reluctant to appoint health and welfare deputies for general purposes, instead preferring to grant orders for a specific situation. So again, that could be quite difficult if there are multiple decisions that need to be made, but the authority granted is only for a specific decision. In contrast, as we've seen, the lasting powers of attorney can be used immediately when required, so long as they have been registered. Expense, it's very expensive to apply for a deputyship order. They can cost thousands of pounds, whereas lasting powers of attorney are more cost effective. I think Hannah's had a case recently where total costs for a deputyship application and dealing with the administration side of things has come to about £25,000, whereas with lasting powers of attorney it's a lot less than that, and obviously it depends on whether you're making both types of power of attorney, and Karen will run through the fees in due course, but it's significantly less than that. Loss of control, the final big disadvantage really that we can point to. Obviously the court may appoint someone who you would not have wanted to act on your behalf if you had the choice as to who you would appoint, whereas obviously with the lasting powers of attorney you are deciding who should be chosen to effectively step into your shoes. Okay, and even if you do already have lasting powers of attorney in place, it is often worth reviewing these to ensure that you have appointed your attorneys in the way you intend and that they have the appropriate powers, as I often see situations where clients have existing documents in place but they do not achieve what they intend. So it's very important that you have considered, particularly, for example, the way your attorneys are appointed. Sometimes people think, if something happens to one of my attorneys, another one will step in, but actually they've not appointed them in the correct way for that to happen. And do also bear in mind that if you have a valid enduring power of attorney in place, that will not cover health and welfare decisions. It will only cover decisions relating to property and financial affairs. So to summarise then, is it worth getting an LPA? Well, it's a big yes. Many people assume that when they get older or sick, their family and friends will take care of them. However, this belief means that in many situations, family and friends simply do not have the legal authority to make decisions. If no lasting power of attorney is put in place, although family might be consulted on welfare matters, the principal decision is often left to local authorities, and so deciding factors are less subjective. The notion of acting in a person's best interests only requires that care needs are met, which means that sort of more personal desires can be ignored. And above all, mental capacity cannot be guaranteed at any stage of life. So the lasting power of attorney can provide you with peace of mind that if anything does happen in the future, your family or those you trust have the ability to make those important decisions to take care of you. So I will now pass you back to Kerin, and she'll talk about our fees.
That's lovely. Thanks, Josh and Hannah. So yeah, moving on to talk about fees, the million dollar question. I promise you we will not charge you $1 million. All of our fees are set out on our website. So please do have a look at the website, have a little explore, because there's lots more information on that. But for wills, our standard will start at £350 plus VAT for a simple single will, and £525 plus VAT for a couple's mirror image wills. For lasting powers of attorney, we have different combinations. So again, it's best to have a look at the website, because it depends on whether you're a single person, a couple, making one type, both types, registering, not registering. So yeah, have a look there. It's all set out quite clearly on the website. The way that we approach wills and lasting powers of attorney is we like to meet with our clients face to face. And as I said earlier, that's by video call at the moment, which is proving very popular actually. And I think we will use it long after this awful pandemic has ended, because it means that clients aren't having to traipse into the office in the snow, and it works very well. You can speak to us from the comfort of your own home. So that initial meeting we provide to you at no expense. There is no obligation for you to instruct us at the end of that meeting. We like to use it as a way of getting to know each other and talking through the issues. And I have to say, 99% of the time, clients do then instruct us to go ahead and draft documents for them. But as I said, there's no obligation. You don't have to. You could park it for a while, come back to us later, or just not. That's absolutely fine. We do offer bespoke advice tailored to your own personal situation, because obviously there isn't a one size fits all in terms of wills, and that's why we also offer packages, will packages, where if your situation is slightly more complicated, maybe for example you've been married a couple of times and maybe you have children from different marriages, etc., then you may find that the use of a trust is more appropriate for your will. And again, if you look on the website, you'll see the will packages that we offer. We've got case studies to bring those to life, and the fees are all set out as well. And then finally, just to mention that we are offering a 10% discount on fees for instructions booked as a result of watching our webinar today. So just mention that when you contact us to book in to see us. So yeah, I think that's all in terms of fees. Moving on now to questions. So we've had one question come in from Richard, which says, with so many second or third or more marriages, any suggestions how to secure for the children of the first marriage while providing for second spouse partner for their lifetime while maximising tax benefits? And that relates directly to the use of a trust. So in that situation, we would advise you to consider using a life interest trust after your death, so that you can provide for your spouse, so they can have the use and benefit of your estate for the rest of their lifetime. But your will predetermines that when they die, your assets go to your own children. So that would protect those children and make sure that they still benefit at the end of the day. So that would be one example of using a trust in your will. There are other examples, and as I say, they are set out in our case studies on the website, so have a good read through of those. So thank you for that question, Richard. I've had another question that's come in from someone anonymously, which asks, do I need to update my will if someone has moved? Well, no, you don't have to do that. If we are storing your will for you, it would be helpful if you could just email or write in just to let us have that new address. And then we keep that alongside the will, but there's no need to update the will just for someone moving. It may be different if one of your beneficiaries has died, and it very much depends on whether the will already covers the situation as to what you would wish to happen if that person has died or not. So that may necessitate a will review. And also just to mention, marriage can affect a will. So say, for example, you make a will and then you subsequently marry, then that will be automatically revoked unless you've made it in contemplation of that marriage. So again, that's another example as to when you may need to come back to us and just to take advice. Another question that's come in, how are you dealing with the signing of wills at the moment? Yeah, that's a pretty key question. So I mentioned that in terms of meeting clients, we're doing that by video call. In terms of signing, there's been all sorts of weird and wonderful ways that we've used to get around the problem of not being able to meet with you face to face. We can witness signing wills through a window. So that means that you keep yourself safe, but two witnesses can still watch you signing through a window, and that can be, in your home or through a car. So we've had clients come into the office in the car park, they stay in their car, and we simply, two of us simply watch them sign from the outside. So, don't let that put you off. There are definitely ways to deal with that. And then just one more question that's come in, again, someone anonymously, can I update my lasting power of attorney? Well, no, if you already have a lasting power of attorney, it's been signed by everyone, it's been registered, then you can't amend that document. So you would need to start again and make a fresh lasting power of attorney. And actually, in terms of registration, that becomes a bit of a relevant point, because we sometimes have clients who have maybe younger children, but they still want to make a lasting power of attorney. So, for example, they may make a lasting power of attorney appointing friends or relatives to be their attorneys, but they don't register it straight away because they intend that once their children are a bit older, they would then make a new lasting power of attorney and they would appoint those children. So that's where it's quite useful. You don't have to register your lasting power of attorney straight away. So I hope that answers those questions. Just one other comment that came in, somebody had lost sound connection. So I really hope that came back again pretty quickly, because I haven't had any other comments about sound and I was able to hear everyone all the way through. So I really hope that came back. But if it didn't, then there is a recording of this webinar available. So we'll be making that available at the end. Yep, here are all our contact details, so please do feel free to contact us direct. You can note them down here, or you can always get them from the Whitehead Monckton website and contact us that way. Oh, just one more question that's come in. Where are your fees packages on your website? So if you go into the wills and succession planning section, there is a tab highlighted in blue for succession planning services. If you click on that, you'll come up with a brochure that sets out the packages, and inside that brochure there's another link to click to take you to the case studies. If you can't find that, just give us a ring and we can talk you through it. Yeah, I think that's everything. Oh, that's good. Yes, the sound did come back, so that's brilliant. Excellent. Okay. Well, thank you so much for joining us today. I hope you found it useful and informative. And as I said, any questions, please do get in touch. Thank you very much. I will now end the webinar. Thank you.